And that is actually exactly the purpose of this webinar, to sort of have an accessible format for a wide range of professionals. So we're very happy to have you, and again, welcome to this event. With these words, I don't want to spoil more of your time and hand over to our esteemed moderator, Right Kuse, and the floor is now yours for the coming 2 hours. Thank you.
Thank you very much, Gustav, for a very good introduction. So welcome to everyone. My name is Right Kuse. As said, I'm a Director General of the Estonian Prison and Probation Service, speaking from the Tartu prison, which is our first new cell type prison we built in 2002. And now, as Estonia is kind of joining, I would say, opposite trend than perhaps Western Europe is joining, that we have less and less prisoners. So we are now considering closing part of this prison already. So we are in the quite, I would say, good place regarding prison infrastructure and use of imprisonment in the criminal policy. But this is not what we are going to talk about. We are going to talk about in this webinar about remand imprisonment and the use, obstacles, and many other issues around it. I'm not going to talk too much here. We have distinguished panelists, professionals across the criminal justice field from different European countries here. And I will very shortly now introduce them for you. First, we have Emily Lönnqvist, PhD candidate, Department of Criminology, Stockholm University from Sweden. Emmanuel Razous, Deputy Director General of French Prison and Probation Administration. Jana Spero, Secretary General for Confederation of European Probation and from European Probation, which is called as CAP, and also a former Director General for Prisons and Probation in Croatia. Then we have Vahur Verde, State Prosecutor from the State Prosecutor's Office of Estonia. Then we have Gabriela Nicoleta Chihaya, Judge at the Brasov Court of Appeal from Romania. And then we have Marina Bön, Prosecutor for the Central Authority in the Netherlands. And as you can see, we have covered all the criminal justice chain, if I may say so, to have this very interesting discussion also for this auditory. The structure is as follows. First, we hear the first presentation by Emily Lönnqvist on the findings of her research titled Prisoners of Process, the Development of Remand Prisoners Rates in the Nordic Countries. And I'm really looking forward to it, as for us at least, I think for many others as well. The Nordic countries build kind of example in many aspects of the criminal justice systems. So we can hear from those aspects as well, and then debate a little bit afterwards. The first panel discussion follows. We are trying to explore a bit about effective use of alternatives to pre-trial detention. Then we have a second presentation. Emmanuel Razous presents key obstacles to France's use of alternative measures and also offers some solutions for overcoming them. And then after that, we have the second panel discussion, and we look at the obstacles and we look how to work with those obstacles, how to overcome those obstacles in the implementation of alternatives to pre-trial detention. So by the end of our time today, we hope you feel more confident about the implementation of alternatives to pre-trial detention. Our goal is to have a productive conversation with the different criminal justice professionals to come up with practical solutions as well. And as we have a very interesting auditory here, I really hope that you have many questions. And as said, Aune will assist us to select at least some of the questions. I will keep the time as well, of course. And we can elaborate on those questions with our distinguished panelists. So now let's go directly to our main topic, and let's start with the presentations. I would like to give floor to Emily Lundqvist, the PhD candidate, Department of Criminology, Stockholm University, to talk about Nordic countries' experiences regarding remand imprisonment. Emily, please, floor is yours.
Thank you so much. I'm very happy to be here today and talk a little bit about my research into the use of pretrial detention in the Nordic countries. And I will now share my screen, and I hope that you see it. Yes. So I'm gonna this article is really packed with information. It's very difficult to attempt to only give a 10-minute sort of brief overview, but I'm gonna do my best, and we're just gonna dig straight into it. So I'm gonna start by just providing a very brief background to the article. And as Gustav talked about a little bit before, we need to, of course, start with the Nordic countries. And usually when we think about the Nordic countries, we associate them with the low imprisonment rates. We think about their open and humane prison conditions and the sort of focus on rehabilitation. But when it comes to the pretrial detention practices or remand practices, we have a very different picture. So as some of you may know, the Nordic remand prison regimes have sustained quite a lot of international criticism, so most notably by the European Council and the UN. So rather than the sort of emphasis on humanitarianism and openness and rehabilitation, we instead find regimes that are characterized by very, very restrictive conditions that often resemble solitary confinement even. And in general, there's a lack of meaningful activities during the detention. So we have a very different picture that arises when we look at the pretrial detention practices rather than the prison practices. But despite this, there actually hasn't been a lot of research into how remand is actually used in these countries. So that was the sort of point of departure in this article that I published last year. So this is a study of the use of pretrial detention in the Nordic countries. And more specifically, I look into how the Nordic remand populations have developed over time. And as you know, maybe remand populations are, of course, a function between the number of people that are held on remand and also the length of their detention. So in looking into these sort of developments over time, I also wanted to see how these two factors have influenced these developments. And this is a comparative study of Sweden, Norway, Denmark, and Finland. And of course, what I was interested in is what differences and similarities apply. And I also wanted to provide some sort of understanding into how these differences can be understood. So we're gonna dig actually straight into just looking at an overview of the study's results. And we're gonna start by looking at the Nordic remand population, which I hope you see here in this graph. So this is of course standardized, so per 100,000 population. And we're looking from 1983 until 2020 here. So first, we can note some general trends if we look at the whole trajectory over time here, or the whole time period. And we can see that there has been an increase in all the Nordic countries' remand populations, except for the case of Finland. If we look, however, from the 1990s, and especially the 2 decades that follow afterwards, we see increases actually in all the Nordic countries that are quite similar as well. But something seems to happen around 2010. So here we have very clear diverging trends instead. So we have stability in Finland, whereas the remand populations has decreased in Norway. And we have quite substantial increases in both Denmark and Sweden. So already here we can note that there are some similarities, but also quite a lot of differences that apply. And like I mentioned before, these rates are influenced by both the number of people that are held on remand and also for how long. So now we're going to look into how these two factors have influenced these developments. So we're going to start by looking at the number of remand placements, which we see here. And I think the most evident first reaction, at least to me, is that the levels are very, very different between the Nordic countries. So we really use remand or pretrial detention in very different extents. And Finland is, of course, a very clear outlier here. But if we instead look at the development rather than the levels, we can see that there has actually been a decrease in the number of people that are placed on remand. So this doesn't really follow the trajectory that we saw in the overall rates, which are then instead driven by increases in the length of detention, which we see here very clearly. So sort of to just conclude here, we can note that there are some similarities, for instance, in the longer detention terms, but we also see some really evident differences between the countries and the extent to which they actually enforce remand. So also, like I mentioned before, I wanted to look into, or at least try to look into how these differences can be understood. And I'm going to start by just showing a table here that outlines some of the factors that we need to consider in understanding how remand is actually enforced. And as you can see, there are a lot of them, and they're really complex factors as well. And I'm sure that we're going to probably get back to some of these factors in our upcoming discussions on alternatives as well. But I decided to look into two of these factors. So I wanted to look into remand legislation, so the legislation that regulates when remand can be enforced in the Nordic countries. And I also wanted to look at crime and the crime development. And here I used imposed prison sentences as a sort of indicator of the more severe crime development, which is based on the assumption that remand should not be imposed when it comes to really minor offenses. So looking into whether these factors can actually explain the differences, I want to start with remand legislation. And I really wish that I could get into very full detail how it looks like, but we really don't have the time. But what we can conclude is that there are some overall similarities or overarching similarities that apply. So for instance, when it comes to the level of suspicion and also the grounds on which remand can be enforced. What is interesting, though, is that there are some differences that actually suggest another outcome than we actually see. So, for instance, there are differences in the against the offenses that remand can be imposed in the Nordic countries. And actually, according to that, Norway should actually impose remand to a larger extent than, for instance, Denmark, which is, as we saw before, not the case. If we look at prison sentences as an indication of the more severe crime development, we also see here some really evident similarities, so especially when it comes to Denmark and Norway. And this regards both the levels and the developments over time. We also see this when it comes to Sweden and Finland, which is, of course, really interesting, given that Finland, as we saw, really imposes remand to a very minor extent compared to Sweden. So here, we can conclude that these two factors just on their own, and of course they're related to a lot of different factors as well, but just on their own, their explanatory value is really limited when it comes to explaining the differences that we see in the Nordic countries. And to conclude and wrap this up, I really just again want to emphasize the really big differences that we can see when we just look at the statistics of this. And this is, of course, also interesting given the similarities that we have in the Nordic countries. And as a researcher, I also, of course, have to say that we need more research into this to unpick the differences that apply. But one difference that could also, of course, be a part of the explanation regards alternatives to pretrial detention. And I wanted to say something brief about that as well. So in the Nordic countries, all have a reporting obligation and travel bans that can be imposed, also supervision to some extent, but these are barely used in Sweden, Norway, and in Denmark. And just to give an example, there have been roughly 50 cases of alternatives that are imposed, which can be compared to 10,000 people placed on remand in Sweden every year. So it really isn't used a lot. And of course, we have some challenges, especially in the Swedish context, I would say, that are related to the principles of immediacy and orality that guide the judicial proceedings. And we'll probably get into that later too. But again, Finland is actually an outlier here as well. So if we look at the use of alternatives, Finland actually imposes travel bans to a much larger extent than we see in the other Nordic countries. So here we see instead 600 travel bans, which can be compared to roughly 2,000 people that are placed on remand. And why this is the case should, of course, be investigated further. And I'm unfortunately, I don't have any answers to this. But finally, I would also just like to briefly say something about the sort of distinction that exists between law in the books and law in action. So like I said before, the Nordic remand legislation is very similar, but these provisions are, of course, based on risk assessments, or they entail that risks have to be assessed. And this, of course, means that there is quite a lot of discretion when it comes to enforcing remand and also alternatives. And I really think that we should look further into the relationship that exists when it comes to pre-trial risk assessments and the legal cultures, and of course also the view of proportionality and the presumption of innocence as well. And of course, this is also related to the larger socio-political context. And I'm sure that we'll return to these questions later. Thank you.
Thank you very much, Emily. Very interesting summary. And what I can also say is that your article published is publicly available as well via internet, so you can find it very easily. I did read, and I was surprised that Nordic countries are not so similar in everything at all when I kind of read that kind of developments there. Mm-hmm. And when you did your study, and you looked at remand imprisonment use and the alternatives and that the Nordic countries, but you probably also looked a little bit outside of the criminal justice system as well, and tried to think that are there any societal or something more general factors which might influence the countries in the Nordic states? Maybe you could share a few thoughts at least before we go to the discussion with the panelists.
Absolutely. I think also, which was evident in the table that I showed very briefly, maybe you at least got some idea, but I think what kind of struck me immediately was how complex the use of pre-trial detention actually is. And usually when we think about prison sentencing, we think about it as politically constructed, at least in criminology in many ways, even though there are also, of course, relationships to crime. But I think what struck me the most was the sort of lack of connection between prison sentencing practices and pretrial detention practices. And I haven't been able to look into these factors more. But like I mentioned at the end here, I really think that we should talk more to people and do comparative studies that actually look into how these risks are actually assessed.
Okay, thank you very much. Very good insight here. Let's move to our panelists. Now it's our turn to elaborate a bit, and let's start from the beginning, if I may say so. Let's start from the prosecutor's point of view or viewpoint here. Marina Böön, please. How would you interpret this topic you saw represented here, and the use of remand and differences among the Nordic states?
Yes, it's interesting to hear and see these figures all, because I don't know these figures from the Netherlands, for instance. I know there is an increase of remand custody, and we try to look for alternatives, but I can see that it's not many times used, and we have also a large number of remand custody. And I think we have an option, of course, to use alternatives and to have people not always in custody before the trial is there. And also, what is my job, of course, is to transfer these supervision measures.
But Looking at you said the use of remand has been rather increased in Netherlands as well. That what is the reason behind? What would you kind of call it? The main kind of, let's say, factors why the remand imprisonment is increasing?
Well, yes, I'm not on that side of the of the information. I don't know what is the reason for that. I just see it around me. Maybe there are more crimes, more heavy crimes, but I don't have statistics.
Okay.
But
your personal professional opinion, as much as you have the information, or you are in this context thinking aloud, let's say.
Yes, well, what I see when I have these cases in court with the pre-trial detention, then I see the cases are heavy. They are more heavy than before, let's say 10 years ago. So I have the impression that there are more severe cases at the moment, more violence, especially violence.
Okay, thank you very much. Let's move to Vahur Verte. Vahur, any reflections and also regarding perhaps bringing the Estonian context here as well, the number of remand prisoners on daily basis has been also reducing little by little, but the proportion is pretty much the same as it was even when the number of prisoners was higher. So could you explain what is behind that tendency?
Good day. Actually, this is an extremely interesting topic, and I was eagerly listening to the presentation. I have been working as a prosecutor almost 15 years, and during that period, I've personally seen changes in legislation as well as changes in case law regarding remand and alternatives to remand, meaning that Estonian legislator has introduced quite a few alternatives to remand, as well as set very strict term limitations, as well as recent case law has furthermore evolved these alternatives and the ways that judges or preliminary judges can use those tools provided by legislator. And it would be extremely interesting to hear or learn about research, whether there's a correlation between recent developments in our legislation as well as in case law and the decrease of pre-trial detention as well as overall prisoner numbers. So in that sense, I do see that there could be some correlation, especially after listening to the presentation, but would be really interested in learning what's the actual situation in Estonia, like scientific reasons, if there is a correlation or not.
Thank you, Vahur, for that. Let's turn to Gabriela Nicoleta Giaia, judge perspective regarding the use of remand imprisonment, and please, perhaps some insights from your side.
Yes, some insights from Romanian judicial system. I'm a criminal judge from 2012. We have an important reform, justice reform in criminal part in 2014. Our criminal code, criminal procedural code, prevent for preventive measures applicable both in the pre-trial section of a trial and in court part. Two of them are non-deprivation of liberty, judicial control and judicial control on bail. Both of them are used by the prosecution and by the court in the pre-trial part of a criminal trial. But we have, although a lot of detainees, and because we have two other preventive measures, house arrest and pre-trial arrest, preventive detainees. So it's we're still working to apply more the non the preventive measure is not in detainees.
Okay, but from the judge perspective, and perhaps could you also kind of give us some insights that what are the options if the remand is considered, that what are the options to consider, also some alternative measures to remand?
First of all, it's the type of the crime and circumstances to the person of the accused person, the guarantee that he could offer to let him in kind of liberty, not put him in prison.
Mm-hmm.
We think about the facts and about the person.
Okay. Emmanuel, I would like to ask from your side as well, that as the numbers are rather increasing and also the remand prisoners, well, they also mean that prison services have to build their capacities in order to meet so-called demand and so on. So reflecting on those different developments given by Emily in her presentation, how would they, or what kind of observations you have compared to the French practice? Of course, you will have a presentation as well, but perhaps some insights already.
Right. Okay. Hello, everybody. Sorry for my English, but we are going to speak about our French system in a few minutes, and we'll be able to explain you what are our solutions to prevent remand population. But maybe I've got a question, if it's possible, for President for Emily. We are curious to know how the Norway managed to decrease their remand population. Is it about legislation, about political or others topics that they are be able to decrease their remand population?
Okay, please, Emily.
That is a very good question, and maybe a representative from both Norway and Finland should actually sit here instead of me today, but I haven't been able to find any legislative changes that have been done in this period. And we also haven't seen any specific differences in the crime development either. So it really is a little bit of a black box, and I'm sorry that I don't have the answer.
So just to add, from my experience, it might also to have something to do with some strategic approach of practices, designing the practices of criminal justice, of course, but probably it needs to be more in-depth explored. So Jana, I'm coming to you now. So about alternatives to pre-trial detention or remand. What is the point of view of CAP regarding that matter?
Well, thank you very much, Rai. Thank you, Emily, for your presentation and for all the speakers before me. And thanks, Europris, for this important topic. It is something that we share because alternatives are usually under the jurisdiction of the probation services. So for us, this topic is very important. This is why I would like to start with reminding us all that there is a recommendation of the European Commission from the December of 2022 on the procedural rights of the suspect and accused persons in a pre-trial detention, where it is basically said that pre-trial detention should be the measure of the last resort, so that we all have to put our focus to find any alternatives to lower the numbers, because we see the space statistics that in many countries the numbers of detainees are rising. So what EU identified as the obstacles of using alternatives was very often the law. Even if there is alternative in law, it can be very specific, like that the law allows this just for a certain category of the offenders. For example, it's only for elderly or something like that. The second thing was like the trust between the stakeholders, which is still one very big issue that we need to think about. Then there is also the understanding of the criminal justice and of the purpose of the criminal justice, because many times this is also involved with the involvement of media, you know, of highlighting the importance of the detention sometimes. And also one thing that is very important, and I guess that other speakers will also mention it, these are the foreign nationals. And I'm happy that also we have here Daniel, who is the chair of the expert group of CEP and Europris about the foreign nationals. But it looks that it's very hard for countries to decide on alternatives to detention if the person doesn't have like an address and it's a foreigner in the country. So from our perspective, we are really happy to see that many countries are looking for solutions. What we see from our CEP members, like the number one alternative would be like electronic monitoring. And then there are a variety of different alternatives that include the supervision of the probation service, but we can talk more later, because if I continue, I will take all the time for this panel, and it's not just for me. So thank you.
Yes, thank you, Jana, very much for this insight. We come back to you, but just looking at the comments section as well, that there is a comment that in Sweden we are politically moving into a direction of more people being remanded and the limitation for remand being lowered. And then there is a question as well, have there been any comparative studies that look at effectiveness of remand use in prosecution? What effects are gained from greater use of pre-trial detention, for instance? I can assume that from general point of view, the negative side effects of any incarceration are visible there as well. But of course, the justification why to use the remand imprisonment are a bit others. I would now continue with the same round, but with another question, that if you talk about the possibilities to have alternatives to remand imprisonment, then what are the key factors to have more effective use or wider use of alternatives to remand? And perhaps we start again with Marina Böön to elaborate a little bit on that from the prosecutor's point of view, that what would make considering the alternatives to remand, let's say, more favorable?
Okay, well, we have, of course, all kinds of conditions which you can order as an alternative to the pre-trial detention. In the Netherlands, we have mostly it's a reporting obligation. Sometimes it's electronic monitoring, or maybe sometimes when there are problems with addiction, then you can also order that somebody gets a treatment in order to avoid recidivism. So we can order all kind of obligations, but one of the important things, of course, is when you have pre-trial detention, how the investigation is going on. If there are still interests for the investigation, the criminal investigation, that the suspect is not, how do you say? Well, when there is a danger that he can influence the witnesses or his suspects, then you don't want to release him at that time. So it depends also on the state of the investigation. But when there is not that kind of interest that he can damage the investigation, then you can think of obligations to fulfill in order not to be in pre-trial detention.
But it sounds to be like a very complicated kind of evaluation to be made, like prior deciding or whether to go to apply a remand imprisonment or to ask from the court applying the remand imprisonment. So do you have any insight about how the process or what kind of tools are used in Netherlands to decide this? It's not a pure legal issue, I think.
No, you look at the different interests. So the heaviness of the case, the interest of the victims. So you look at all those interests, and then in relation to the personal interest of the suspect. And then you have to measure what is the most heaviest in this case. So, and when you don't have a big personal interest, then mostly the interest of the criminal investigation and the protection of society is more than bigger, and then you stay in custody. So that is mostly the consideration of the court.
Mm-hmm. Mm-hmm. Thank you very much, Vahur. I come to you just to ask that. Well, aren't prosecutors perhaps too easily asking for remand?
That's an excellent question. It depends on crime. It depends on crime being investigated and prosecuted. We always take into consideration that our criminal procedure code sets extremely strict time limits for remand to be applied. So those time limits always set ourselves, so to speak, inner boundaries. Those cases where we go to court to preliminary charge to seek remand. However, once we do find it absolutely necessary to apply for remand, to request remand from the plenary judge, the second question is that our criminal procedure code is set up in a way that we cannot directly seek for lesser alternative, meaning that even if we do find that, for example, bail or electronic monitoring device would be sufficient, our current law is kind of, in a way, too rigid, in that sense that first we have to seek remand, and only after preliminary charge has granted remand, we can seek for alternative, like lesser alternative. So in that sense, this present system is not that flexible. And that also puts us into a position that we, in cases where we have two options, either reporting obligation or second option, remand. And when we see that just mere reporting obligation is not sufficient, and we would like to add additional elements, for example, electronic monitoring or bail, or then we are kind of like in a difficult situation that we have to seek for a more severe alternative first, and then only then that we've been granted, and we can seek for lesser alternative.
Yeah, thank you. Yeah, it can, of course, it depends a lot on the domestic legislation and how the architecture is there, what needs to be asked first and so on. So I think that this is a very, very valuable point here. Gabriela, Nicoletta, from the point of the charge, what would create more trust towards using alternatives to remand imprisonment?
It's very difficult to answer that questions, because it depends a lot of the files, the type of the crimes, and very, very much depends of the person of defendant. If he or she is a trust person. Because in Romania, for example, non-custody measures, I said previous that we have judicial control, but it's very, very like liberty. We can just put some obligations, that the defendant must following in this period. Our criminal procedure code said that we can put electronic surveillance system, but in fact this is not applicable in Romania, because we don't have this kind of surveillance. So this was a very good measures required to the defendant during the judicial control, and the surveillance for the police officer was much easier to make. In fact, we can oblige the defendant not to go in some place, not to exceed a specific territory, boundary, not to travel in some place, not to practice a profession, go to I don't know, sports to take part in sport or cultural events, not to return in the family's dwelling if he is accused by domestic violence, for example. But it's very, very hard for the officers, from the police officers, to supervise this defendant in this case. So we must trust that the defendant will respect all the obligation that the courts or the prosecution establish for the pre-trial part.
Thank you very much. What I hear from here is that country by country, of course, there can be also a lot of differences who implements what. And I think that when you're talking here about supervising by police, in some countries, the probation officers are equipped to supervise alternatives to remand imprisonment and so on. So it's a combination of different kind of measures and arrangements. Jana, from the probation.
Yes, if may I, in Romanian judicial system, all the pre-trial parts are in supervision of the police at the measure. after the part of, and if we have convicted, the supervision is in probation system's role.
Yes, and then that is very good explanation about that difference, because you always need to look at whether the countries you're comparing are similar or not. But from the presentation, we heard that Scandinavian countries are rather similar, so you need to kind of dig a little bit deeper to understand that what exactly in those neighboring countries is influencing more the use of remand. But Jana, coming to you. You started with the word trust here, and I kind of hear as well that that the trust that something is implemented, what kind of alternatives and measures are available. That is a big influencer of how many remand prisoners you have in the respective country. So, what are in your sight, the best kind of practices from the probation services side, that how to support? Or how to meet all the interests which we heard here from the prosecutors and the judges' perspective, and also perhaps to avoid the negative effects of the imprisonment?
Mm-hmm. Yes, thank you very much for this very challenging question. Well, of course, it's not easy, and what you said, it's like a very variety of countries have a different situation and different kind of services, because for us it's important that we share all the same values, but we appreciate that we are different. So like what you said, somewhere it will be the Ministry of Interior, somewhere there will be a probation service, sometimes probation service is run by NGO. So one of the key issues that we saw from the CEP is the level of communication between all the stakeholders in the criminal justice system. So it's very important for the prison service and the probation service to have a constant dialogue with the prosecutors and the judges. The trust between the judges and the enforcement agencies is crucial. So the judges need to be aware of the meaning of the detention, to come to visit the prison and also to visit the probation service to hear about different alternatives, because there is also alternative within the alternatives. So for some, electronic monitoring will be the best alternative, but for some there will be like some kind of a probation supervision, better idea than the electronic monitoring. So it goes back to what Emily was talking also, that we need to have like a risk analysis, and there will always be offenders who will have to go to the detention, but they are high level. We have a high level of fear that they will recommit a crime during this time. But if we have a lower level, like we had a webinar about alternatives within CEP, and we had example from the Greater Manchester area about a special programs for a female, where they found the statistics that 81% of women wouldn't create a special threat for the society if they were outside of the prison. So this is also something that we need to see. So some will need to be inside, but some can be outside. But I think, because you started the question with the trust, that is very important that we communicate, and when we communicate, that we are very straight with all our strengths and with all our weaknesses, so that we can have informed decision on how to do like a triage. I think that the triage should be like the key question for all of us.
Yes, indeed. And our time for the first panel discussion is up, but I would like to reflect on two questions I see in our question box or remarks. One, what was here already heard, was that the remand imprisonment might influence, that coming from Spain, is influencing more the foreigners who perhaps don't have permanent residence and so on. They are more in a vulnerable situation in the countries, and so they are kind of overused in terms of the foreigners. So that is one of the comments or observation. And the other was the question that how to balance the offenders and victims, right, as well, because you should not forget that every crime has a victim as well, and then to keep the balance that how to maintain security and order, and also balance that what are the offenders' rights and perspectives and the victims' rights and perspectives. So this is the reflection, and perhaps we leave this balance question for the next session. Now I would like to first thank you for your contributions, and let's move to our second presentation. And second presentation is to be made by Mr. Emmanuel Razous, Deputy Director General of Prison and Probation Administration of France. So please, Emmanuel, the floor is yours.
Yeah, thank you very much.
We're going to share our screen.
We are going to share our PowerPoint. Where is it?
This
One? That one?
Yes, this one.
Yeah.
There you go. Can you see it?
Yeah, very good. Can you see it? Okay for you?
Not at the moment.
Mm-hmm. Daniel is working.
Okay, it should be this one. Can you see it?
No.
No, not at the moment. So we don't see any presentation yet.
Question to Aune. Do you have the French presentation?
No, she has that. Oh,
We can share it from our account.
okay. Right there. Very good. You can see it now.
Yep.
Yes, now it comes. Very good.
Okay, great.
Okay, thank you very much. I just want to say that I am a magistrate, French magistrate who is working now in the prison and probation administration for 4 months now. And so I can see the two sides of the problem, you know, because before I was a prosecutor, and now I work in administration with probation and jails. So it's a big challenge for me, and I can have the two sides of the problem. It's very interesting. Well, some words, and Daniel will help me sometimes if necessary, to say that we have for the pre-trial detention alternative, we have two alternatives. The first one is of course the judicial supervision and electronic monitoring, house arrest, and we have increased the use of alternative due to laws targeting pre-trial detention, reduction, and prison decongestion. The trends are that despite more revenge prisoner, alternative measures are on the rise, and judicial supervision and electronic monitoring usage have grown due to different recent law, 3 recent law. You can see them on the PPT. 3 recent law, very important. Well, we have to understand that we have to say that we have an innovative supervision strategy for domestic violence defendants. You have to know that in France, maybe in the other European countries, the domestic violence are increasing and the defendants are numerous. The initiative was to build probationary placement under judicial supervision since 2020. We have a legal foundation, of course, and what is important in this placement, probationary placement, is the access to health, social, educational, and psychological assistance, and even the judge can oblige the defendant to reside in a certain place, and that's very important, instead to go to jail. It provides this placement can provide to the judge detailed information for tailored sentencing decision, and to have a decision, of course, more precise and more personalized. And now, for the moment, we've got an ongoing evaluation study to measure the effectiveness and societal impact of this measure. If you want to offer that credible alternative to incarceration, and maybe a word about what we were talking a few minutes ago, and some of you have already said that we have to reassure the magistrate. I am a magistrate. I was a prosecutor. And I realize now how is it important to reassure the magistrate that the person, the delinquent, will be really supervised. This is a real challenge for us in a society, you know, in our societies where people are more and more frightened about delinquency, and that's a real challenge for us. You know, I think that the work of the defense lawyer, we didn't talk about defense lawyer, but I think that the work of those defense lawyers is very important too. They have to help the judge in the choice of the sentence, to avoid the pre-trial detention, to prepare the case ahead, to see, for example, if the man or the woman have a job, have a residence, and so on. Well, that's for me important. Concerning probation services, what is important, of course, I was speaking about to reassure the magistrate. I think we can say that in France, probation services are in progress. They are guided by the handbook methodology. They have improved the quality of risk assessment and supervision over the last 6 years. As an innovation, we have the introduction of an actuarial tool in 2023 for precise reoffending risk assessment, complementing the ODERA tool. All those tools can customize supervision plans to individual profiles. Concerning electronic monitoring, 2022 memo established structured procedures for alarm management, prioritizing EM profiles. We are committed that the prison administration ensures rapid electronic monitoring setup. That's important for the judge. The prison administration ensures rapid electronic monitoring setup and effective communication with the judiciary personnel. The Ministry of Justice advocates for prison regulation. You know that in France we have a very big problem of overcrowded prison. And the Ministry of Justice advocates for prison regulation to alleviate that overcrowding and enhance sentencing. What provision if an alternative? Yes, yeah, we can move on because the time is not so long. What is the impact? Concerted efforts towards refined intervention methods and professional practice in probation service, fostering a more efficient and just legal system. We have a paradox. We have to unpack the underuse of a pre-trial alternative, despite of all what we have implemented. We have a prosecution evolution, shifts of crimes types, affect pre-trial measure application. I was speaking a few minutes ago about people who are frightening about nowadays delinquency. We have now prosecutors who favor quick trials, often resulting in detention, because if they choose this type of trial, it's because they want to have a detention because of the violence,
because of the violence, the type of crimes, the types of crime which can be very violent.
Increased criminal offense front a rise in detention, the same subject, and the recent trend towards harsher responses, especially in domestic violence cases. Well, to end, we can speak about the socio-economic status and nationality significantly impact legal processes and outcome. We can say that our public, our delinquent are people homeless 5 more times more likely to undergo summary proceeding, 11% remanded in custody, and 50% receive unsuspended prison sentences are people homeless. Second point, people are generally unemployed. I was speaking a few minutes ago about the job. Our people is 3 times more likely to face immediate appearance trial. Unemployed people is 25% more given unsuspended prison terms. And at the end, we have also foreign people, non-native individuals. They are nearly 2 times more likely to be tried by immediate appearance than quick trials that we have in France. 5% of non-native individuals remanded in custody, and 25% sentenced to prison terms.
Yeah. So yeah, basically, what Emmanuel just said, actually, depending actually what your social background, you're most likely and ended up in prison or for remand or for prison sentence term, definitely. So it has a huge impact on actually where you stand in the social ladder. And what we try to boost actually the result, because like Liana said, the pre-trial detention should be a last resort measure. So in France, we try to boost the adoption of this alternative. Yeah. And why we did it? Actually, this collaborative dynamics, talking with judges on a regular basis. Yeah, not just on a policy level headquarters, but on local level too. We strongly encourage our prison governor, our interregional director, even our probation officer on a daily basis to engage in dialogue with the judiciary, with the judge. Of course, you will provide the support regarding EM. Okay, all right, okay. Emmanuel is reminding we don't have much time left, and provided guidance regarding breaches, because it's about trust. So we have to make sure actually we bring guarantee about the quality of supervision, whether they're on remand or on remand or anyway sentenced to. So basically, it's having a strong partnership with every single stakeholder, partnership regarding accommodation too. So that's why we work close with the NGOs too, with the different Ministry of Justice. Okay, that's okay. All right.
No,
so. Oh yeah. So thank you, and we are ready to open to your questions.
Thank you very much. Very interesting perspective, and I totally agree with you that you need enhanced collaboration and also concrete strategic aims to overcome all those obstacles. But I have one question for you. Have you also had the discussion about a possible kind of net widening effect, for example, that if you are introducing more electronic monitoring as alternative to remand imprisonment, but instead of those who are going to be in the remand prison, you will end up with more people on electronic monitoring who would get, for example, the restriction to leave home or something like that. Is that also something to be looked at in front?
Unfortunately, that's reality, not just us. We got our colleague, our cousin from Belgium too. The net widening is basically, suppose that's why we need to be, that reminds us actually, Fergus McNair, we need to be very careful when we sort to we create, actually implement an alternative and make sure actually it doesn't come another way to punish or to put someone under the criminal justice system. So yes, you're right. We got more and more people under EM, whether on pre-trial, but even when they are sentenced, let's say we got about 18,000 people under electronic monitoring, and regarding EM front door was used on the front door, maybe we got 500 basically, and then yet we got more people on the pre-trial detention. So yes, the widening effect is right there. We cannot deny it. So it's up to us actually to explain actually to the judge actually the kind of sentence they are. Yes, the sentence, does it have what's the true purpose, the true sens de la peine? Yes, that's the job actually, to explain to us actually, to the judge. Now more and more they refer to a sentence, any kind of a sentence, yeah, but does it have a sense, a meaning, true meaning for what the purpose of the sentence they are put it? That's where we are right now actually. And like kind of educate not just our staff, educate the judge, educate the whole society about what we're doing, and not to be ashamed of what we're doing, because we are doing this is very important work. Yeah.
Yes, thank you very much for this reflection. Jana, I come to you now. Do you also discuss among the professionals from the European Probation Services what are the obstacles and what are the opportunities to use perhaps more remand alternatives to remand imprisonment? Is that something which is sound also in the circles of probation?
Well, absolutely. The probation service is here very connected, and this is also what we are talking. So we are here talking about the laws and about the capacities and about the trust. This would be like the triangle that we need to have. First, we need to have enough of the probation officers that are well educated and trained to work with cases that are different from the typical case, but that need maybe more attention. So it means that there will be more contacts, more supervision than in some other cases. On the other hand, there needs to be a law that allows probation service to be involved. So this is something that is very important. And yes, all the probation services are thinking what to do and how to cope with this. I can tell you from the Republic of Croatia, because this is originally where I come from, and as you said, I was Director General for Prison and Probation. We had a really big problem with having like almost 50% of the prison population in the remand. So what we did is like we only started with the EM that could be used in the pre-trial, but we also tried with different alternatives. Like one is not one of the known, so this is why I want to mention it. There is a possibility that prosecutor talks with the accused and decides on some kind of alternative even before starting the criminal procedure. So if the accused person do some community work or undertake some treatment for the violent behavior or a drug abuse treatment, then this person will not even go through the criminal procedure and the case will be closed and there will be no file on the person later on. But this all is like on a small scale level what we do, but the good thing is that every service is trying to do something, but we go again, to sometimes the trust. And as we had one question, what about victim? This is also the thing that very often unfortunately, we have terrible cases, and Mr. Emmanuel mentioned the domestic violence. And the cases of domestic violence very easily are something that is on the headlight, you know, of the newspapers. And after one bad case, many time it's very hard for prosecutors and judges to decide on alternative to detention. And this is something that we need to also have something from probation, and this is holistic approach, because not all the cases are the same. And it is very hard. It is very hard to do the assessment. It is hard, but sometimes this is what is our job, that we need to do assessment. And sometimes, no matter of the bad old cases, that we need to decide that there are different cases and that alternatives may be also good for certain person.
Thank you very much. I'm really happy that you also touched the issue of diversional measures, which is really important, how to influence have influence without engaging the criminal justice system in full capacity. And that is also very widely used in Estonia as well. But coming from that, that when we reach to the court hearing, and then Gabriela, Nicoletta, this is a question for you. When there is an issue whether to impose remand or alternatives, I suppose that at that stage, for you as a judge, there are very limited options already. So what to choose?
Yes, you have perfectly right, and I am perfectly the court with Jana said. For example, in domestic violence, it's very hard to decide to let the defendant in liberty, even with custodial measures, but not in prison, because the risk to return at the domicile and to maybe revenge on the victim is higher. And if may I respond to the questions from the chat from the previous section. Of course, we must take into consideration the victims, especially when the defendant and the victims are from a little community where they are neighbors. It's very hard to let the defendant to return at home in that community, because the whole community must react of this measure. So in court, we must take the consideration even the public reaction on the for the defendant because of the crime he supposed committed, and all these things we must take into consideration. In Romania, we, as I said previously, we are very limited to the this kind of measure and the supervision of the defendant in pre-trial. So
thank you. Thank you.
We use the judicial control, but most of the crimes, important crimes, the defendants are put in prison all period of pre-trial.
Okay, great. Thank you for that contribution. Very important indeed. Vahur, Jana spoke a little bit about or reflected to the diversional measures as well, that this is also, it's not always the issue of, to create certain alternatives to exact remand imprisonment, but it's also, you need to look at what happens before that, when you reach to that decision, I guess. And I know that the Estonian situation is such, or the practice from the prosecutor's office side, that the diversional measures are used very often.
That is true.
How to kind of, is that a tool which actually kind of hinders the need to go to ask for remand imprisonment? Is that effective? How do you consider that? Should we bring that also to the picture in this discussion?
That is excellent question. To be honest, I'm not sure whether the cases overlap, meaning that in those cases that prosecutors feel the need to go to preliminary judge and ask for a remanded sentence are often more serious cases than those that Jana described. We do very widely use all kind of alternatives, meaning that try to effectively prevent further criminal investigation when we actually feel that there is possibility to act and close the case without sending the suspect to a trial, either to certain social program or asking for other control mechanism to be put in place to alleviate the situation. But in my personal practice, yeah, those are the cases that are lesser impact and not that grave cases. So the overlap is not that great.
Okay.
That's my personal view.
When you reach the remand, then it's already a lot more serious, a lot more risky case, and so on. But do you agree with me that all the risks cannot be brought to the zero anyway? So you need
that's always the case. I mean, it's always the case of weighing different options, weighing different risks. For example, if you have a case with a group of suspects, you always have to weigh what their rights as well. For example, if you have a group of 5 suspects, whether you should seek alternatives to some suspects, whether ask for bail or electronic monitoring, and whether you should do that for all 5 or just 1 or 2. And if something happens, those who were alternatives were used, for example, one suspect, bail was used, he flees, well, what happens to other 4? So it's always a matter of weighing options, weighing risks. And yeah, the bottom line is it's impossible to reduce risks to zero. It's and in that sense, I totally agree with Mr. Razuza, meaning that it's often a matter of first, of course, raising awareness. What are the different options on the table? And second, it's utmost important to have effective cooperation between defense lawyer and the judge, as well as defense lawyer and prosecutor. So there's always a possibility to gather more information so that the prosecutor can ask for effective measure, either alternative measure to set. And there are always possibilities to choose the most correct path. But in order to do that, you need to have information as a prosecutor, and in order to get information, you need to have effective cooperation with defense lawyer as well.
Thank you very much, Marina. I come to you now regarding this issue, which is, I think, very important in that discussion, is that how to balance between the interests of victims and offenders as well in that kind of procedure or making decisions, what kind of measures to apply in terms of offenders. So how do you held that debate there in your country?
Yes. Well, normally when somebody is arrested in the Netherlands, then probation will be informed. So everyone can have a talk with probation. And then in those cases where there are possibilities to go for alternatives for the pre-trial detention, then probation will make a short report. And in this report, all the social circumstances and the risks are being evaluated. And this report is for the prosecutor and for the judge who will decide on the pre-trial detention. And it happens also that probation will contact the prosecutor to see if there are options for an alternative. So then when we have the information, then we will look at the balance also, of course, what is the heaviness of the case, because some cases are so heavy that you can't, society won't accept if you release those suspects. So that's also a very important factor. But if you can explain to society that there is a reason to release somebody from pre-trial detention and you take some measures, then the court will allow it. And the prosecutor always will give his advice before the court will decide. So it's, yes, we have to consider all the circumstances, but of course also to see if there are possibilities to help the offender and to avoid that he commits new crimes. So we always look at what possibilities there are to help somebody.
That's great that you bring in the societal view about certain offenders and offenses, and and also the other thing I really liked that you touched also the role of the probation officers making the pre-sentence reporting and advising as much. I have actually two questions now for you. First is that how big is the difference how the probation officer describes the situation and proposes alternative, and the prosecutor in the end kind of, do you agree, like in most of the cases, with the views of the probation officers, or there are certain elements which actually cannot be met anyway due to some role differences or legislation?
Well, I didn't investigate it, so it's you look at each case by case, and sometimes also when there is a request for release from pre-trial detention, then we say, okay, well, we can think about it, but first we demand that you come with a plan. So then the probation will help to make a good plan, that we know somebody has daily activities, and that he avoids the criminal contacts, and that well, there are not so much risk anymore. But then we just ask first for a very good plan, and then we can agree with it. But yes, all cases are being examined by itself. So I can't say in general in how many cases we agree or not. No.
Yes, that's totally understandable, but I still kind of hear from you that kind of collaboration, trust and understanding of each other's possibilities, capacities is very important here, that the probation service as such must be equipped also with certain resources to deal with the person, like outside, and also to kind of guarantee kind of that the proceedings can go on. But the other thing I wanted to touch here is that the public perception, that what we can see also in Estonia sometimes is that the public perception about that what the concrete offender deserves might be very different from the science. So, for example, that we all know that certain longer sentences, perhaps the reoffending rate can be lower than for shorter sentences in prison, for example, because of some serious social issues there, addiction and so on. And then the demand is like not to use alternative measures because of there is a feeling that the person doesn't deserve it. But from the very let's say scientific perspective, you should use all the alternatives. Isn't there a bias? How to overcome that?
Well, I don't know. When we have cases, we try to explain to the public as well what for what reason those decisions are being taken. So we have a judge who will talk with the press, and we have a prosecutor who will talk with the press. So in that way, we try to explain to society why certain decisions are being taken, and then we hope that there is more understanding. So just to explain to the public, and sometimes, of course, public doesn't agree when severe offenders are being released.
Yes, indeed. Thank you for that contribution, Emily. I turn to you. That it has been very practical discussion here around about some possible reasons which are also perhaps influencing on the use of remand imprisonment. So did you get any new hypothesis for your further research about Scandinavian countries?
Absolutely. I hope you can still hear me, because my
Yes.
one AirPod. Yes, good. No, it's really interesting to hear every one of you talk about this, and also the very clear sort of intention and will that is behind finding different alternatives, and not only implementing them, but also using them successfully. And I can only talk from the Swedish perspective here, and we're seeing a very, very different trend in Sweden, not least when it comes to sort of attitudes toward remand or pretrial detention. And of course, this is also driven by gang-related crime and increases in that. But what we can see increasingly is that there is an intention to expand these practices rather than the other way around. And I also think it's interesting that we're experiencing these overcrowding problems now that we've never seen before. And the solution is not really to find any viable alternatives, but instead we're just focusing on expanding and building more remand prisons.
Can you hear me?
Now we hear you, yes?
Yes. So now.
Okay. Now I don't hear you, sorry.
Willing, and also really trying to find alternatives. I can also say in the Swedish context, we've actually had discussions about implementing electronic monitoring not that long ago, only about 6 or somewhere around there. And I can also mention that the prosecution authority, as well as the Swedish Prison and Probation Service, were actually quite positive to these alternatives. But the proposal that was brought up in an investigation in the legislative era, it wasn't even brought up in the government bill. So I think that the first step in Sweden is definitely getting legislators and political actors to see these alternatives as viable and efficient, and as Jana was saying before, really treat pretrial detention as a measure of last resort, because that is not really what we're seeing right now.
Okay, now let's thank you very much, Emily. I take now some questions, and I leave the floor open for the panelists to respond. So I read the first. Are probation services resistant to getting involved with the supervision of pretrial defendants? Do they have the resources to do so well? Do you think supervising pretrial defendants is a role of probation, bearing in mind that defendants are convicted and presumed innocent? Should it be a role for a separate agency? So who would like to elaborate on that? Maybe Jana.
Thanks, right. As it's connected to the question with the probation service. Well, of course, I already mentioned in my last part of discussion that the probation service is not just regarding the pre-trial, regarding every task they have. They need to have enough staff, and they need to have a staff that is well trained. So this is the capacity building, because otherwise we can't talk about a good job, because we need to be assured that we are working with a qualitative thing, not just, you know, a quantity thing. So for this reason, because we see how important this is in probation services, we started an expert group on caseload and the workload in probation services. So please stay tuned with CEP for more information. We just gathered the expert groups, and we hope that we will come with more information about this, because we know how important this is for every probation service. On the other hand, I think that the question of if somebody is innocent or not is not really a question, because the professionals work in accordance with the judgment, the court order. So for them is less important if there is an innocence or not. It's just important that we know what is the structure of our work. So this is like in many prisons, they have both people in remand and people serving the sentences under the same staff, but we know clearly how to do, because in both prison and probation, the work is very structured. So I think it's up to every service on its own to see the capacities and the possibilities. This is the first on top of my head what I can say about the question you raised.
Thank you very much. I take the second one from here, that are there joint working groups, interinstitutional or at national or local level, which have regular meetings to discuss inflow and outflow of pre-trial detainees and try regulating this process in order to avoid as much as feasible overcrowding at the pre-trial detention stage? So please, good practices are needed here. Anyone wants to respond to that?
I can give a short insight from Estonian perspective. For quite a few years, I was prosecuting high-level drug offenses, where we had, well, they still have ongoing working groups, regularly working groups that involve different bodies, either from prison remand services, as well as from prosecutors and judges, as the courts. And one of the reasons why we came together around the same table was to share best practices, raise awareness, and it kind of resulted in mutual trust and high level of awareness, meaning that in the end we all understood and agreed upon that the main goal is to reduce further crime and to actually help the suspect. So during those work groups, we also discussed what are the most modern alternative measures, what are the possible alternative programs that could be actually implemented as alternatives, what are the good practices, what might be best practices from abroad that we should try to implement. And as a result, I can assure that it actually worked, meaning that I'm not in part of those groups, but they still come together regularly and share best practices, and this mutual capacity building and raising awareness actually works, so that in cases where previously prosecutor might have had some doubts whether some alternative would be effective, now thanks to those roundtables or working groups, we have this inner belief that those alternative measures, they actually do work, and we fight harder to try to get them implemented in court.
That's very good here. I think that kind of collaborative approaches are very important actually to actually also build trust among the stakeholders to use certain new measures, perhaps even. Well, I don't think that it was because of the shortage of prison places why you discuss this, because here we don't feel that kind of pressure in a way, but other obstacles, other considerations probably were more dominant. So let me take another question from here. There is a question from Joanne McPadden. I was just curious if there were any variations, trends across the jurisdictions with regard to alternatives used for women and also those under 18 years of age. I think that just from my personal knowledge base that most of the countries have certain special arrangements if it concerns the juveniles at least. And for example, in the Estonian context, I would say that from a very practical point of view, it is a very rare occasion when a juvenile enters to a prison as a remand prisoner or even as a convict. So it's at the moment, I must say that we are unfortunate that we have one juvenile in the prison. We enjoyed for a few months zero. But the legislation is the key there, that how to kind of influence. But looking, Emily, you did that kind of comparison, and did you also look at the age distribution on remand prisoners?
That's a very important dimension, but I didn't look into it. But I think it applies in all the Nordic countries that special provisions apply where 15 to 17-year-olds can only be remanded unless it really aren't any other alternatives. And I think that's quite interesting as well if you look at the trends over time. When you see that more people of this age, 15 to 17, are actually held on remand, it very much reflects, of course, the crime development and maybe not only the other factors that apply. So for instance, in Sweden, we have a lot of young people that are held on remand now, children. And this, of course, reflects the increases in gang-related crime that we have now.
Okay, thank you for that, Emmanuel. Perhaps you would like to also add from the French perspective regarding the juveniles on the remand in the prisons. Is that a kind of area of concern for you as well?
What we're trying to say actually is it's not when it comes to sentencing or to put someone on remand, yeah, it's not a matter of gender, of ages, yeah. Although we can say we got just 3 or 4% are inmates, individuals in prison are females, yeah, and we got few minors, let's say about on a nationwide, probably 1,000, let's say less than 1,000 juvenile, but has to be actually based. The foundation is the type of offense, basically. It has to be something very, very serious to put some a woman or a juvenile on remand. Yeah, so it's not a matter of gender, ages. It's a type of offenses.
Okay. We have last 10 minutes. Before I take the last question from the question and answers section, does anyone want to reflect from the panelists on those issues we just discussed?
Maybe just to add regarding the juveniles, that the detention during the investigation phase is really the last resort in Croatia. So there are many different measures, but they are under the social welfare services, and there are special like social welfare centers for the juveniles if needed, sometimes that they need to change where they live, but otherwise all the measures are that they stay inside the home and they have some kind of a supervision of the social services. And regarding the female, there is this example of in the Great Manchester area, there is some information on CP website. Okay, thank you.
Thank you very much. Looking at the questions here, we have two more here. First, there is a question from the probation officer from Malta who is asking that what about standard caseload of the probation officer? Is there any European probation services caseload limit per probation officer? Jana, maybe you know. I don't know such limit actually, but I think that it's in every jurisdiction. It depends a lot at what the probation officers actually do.
Yes, it's yes, like what you said, right? It's from jurisdiction to jurisdiction, if I understood it correctly.
Yes. Okay, so let's go further and then just perhaps how we calculate the current caseload here. Just probably it is interesting for Malta is that we see that around 30 persons per probation officer nowadays is kind of a good caseload in Estonia, at least what I know. So, but it has been different. And then there is a last question that often are restorative measures such as victim offender mediation circles used as an alternative or as a part of the solution to find an alternative to imprisonment. So any experiences with the restorative measures implementation and use as well? Okay, here
Yeah.
not much. Yes, okay, please.
Okay. If I may, if we may actually, there was a movie recently, actually last year, Je verrai tous vos visages, I will always see your faces, yeah, talking actually, it's about restorative justice measure in France, actually, everything, yes, from the mediation, for the meeting, and so on, actually, with the victims, the offenders, okay. And there's a huge, actually, increase of demands of from a victim side, okay, this is good, this is what I want. But we have to be bear in mind, actually, this is not a magic wand, yeah, and it's not a panacea, and it's not going to fix everything. So we need to be careful about it. And first of all, to assess, does it work? We need to make sure we have enough. We were talking about Gianna, I was talking about caseload. So we know actually this kind of, you know, sometimes probation officer with a 70, 100 caseload, it does have enough time, resources, energy to invest. Yeah, so we need, it's not a magic wand. So so it's many factors, yeah, to make it works. When it works, it's wonderful, yeah. But yeah, this is what we're trying to say, basically.
Yes, thank you very much. So we have come to an end of our webinar at the moment, and let me wrap up a bit. And first, we started with the introduction of the Scandinavian or Nordic countries research. And I think that, at least for me, the key takeaway from there is that even though the countries or different jurisdictions seem to be rather similar in terms of legislation or challenges, or even the regional context, then to understand the dynamics behind the figures still needs more in-depth view and understanding, not only the criminal justice setup, but also what is the environment around the criminal justice, what is influencing exactly. There were many issues brought, like later on in the discussion, that what about foreigners, what about certain practices, what about even I think that politics, and that has to be brought into the picture. So it's never easy to say that what exactly is influencing more or less. But the other key takeaway for me, at least, is that we need to explore that, and we need to understand, because if you don't understand something, there is a way actually to look at the facts, to set a hypothesis, and to investigate and to understand and how perhaps to keep certain successful aspects of the criminal justice going, what kind of new measures we would need, and so on. So this was very, very good insight given by Emily Lönnqvist to us. And the second presentation from France, from Emmanuel Razous, was very beneficial because it also kind of explored very practical aspects and importance of collaboration and understanding of the different stakeholders' roles and activities. And also not only the roles and the activities, but also the capacities. So in a way, I think that it has given quite a lot of understanding for us that there is a need for networking, collaboration, building trust, also that inside the criminal justice agencies, the collaboration and sharing the same aims, it's not just appearing, it needs a work and collaboration behind it. I thank you, Emily, Emmanuel, Jana, Vahur, Gabriela, Nicoletta, and Marina for very good contributions. I thank you, Gustav, for leading us in. Aune, thank you for excellent setup and keeping us online as well, which sometimes is quite difficult if we are working not across even Europe, but also across globe, as we saw, like in the beginning, that we have participants not only from Europe. And I hope that you got what you wanted from here. At least those who asked questions, we try to cover them. So you definitely get the possibility to engage in the discussions more actively. And I'm really looking forward to see that the discussion about alternatives to remand imprisonment and also alternatives to imprisonment is ongoing and is supported, as we all know that long incarcerations do not necessarily work all the time in the best way we want. So thank you very much. This is the closing from the side of the Europris, and I hope to see you in other occasions as well. Goodbye.